Thank you for being here. I'm Janai Nelson, President and Director-Counsel of the Legal Defense Fund, LDF, and on October 15th, I argued before the United States Supreme Court in Louisiana versus Callais. That courtroom represents generations of fights for fair representation, including many of those brought and argued at the Supreme Court by LDF. Louisiana versus Callais is about more than just maps. It's about access to power, and it took all of us to get here. I'm so glad to be joined in conversation today by my colleague, Leah Aden, who is a senior counsel at LDF, and another Black woman who has stood at the very same podium arguing before the Supreme Court in 2023 in another redistricting case, Alexander versus South Carolina NAACP. Together, we'll talk about what that experience was like, what this case means for the communities we serve, and what comes next, no matter what the court decides.
Hello, Janai. It is so fantastic to be in conversation with you today. Just last week, you argued before our U.S. Supreme Court in Louisiana versus Calais. It is an experience I have the privilege of sharing with you as a fellow LDF attorney and Black female oralist before the court. So, before we dive deeper into the argument itself, Janai, can you briefly explain how this case even got to our U.S. Supreme Court?
So LDF successfully sued Louisiana in a case called Robinson versus Landry for the state's failure to provide electoral opportunity for Black voters in violation of the Voting Rights Act. That case was filed in 2022. And in response to that litigation in Robinson, Louisiana developed a map to try to remedy that Voting Rights Act violation. And it also wanted to ensure that it met its political objectives, like protecting powerful incumbents in their districts. And so, consistent with history, in response to the new congressional map, a group of self-styled non-African American plaintiffs challenged the map. They claimed that Louisiana was using race in an impermissible way. They said they were being discriminated against. And then a 3-judge federal court in a 2-1 decision agreed with those plaintiffs, and LDF in Louisiana appealed the decision, which went directly to the Supreme Court. And then the court heard argument in the case in March, where LDF attorney Stuart Nafee did a brilliant job arguing that the lower court legally erred in concluding that Louisiana used race to create their maps in an impermissible way, I should say. Then in a very rare move, the court did not issue a decision as we anticipated at the end of the term, and instead set the case for re-argument and directed the parties to address a broader legal question that involved constitutionality.
Do you mind walking us through what exactly this broader legal question was that you presented last week at re-argument?
Yes. So the very specific legal question, the question presented, which is how the court tees it up, was whether Louisiana violated the 14th and 15th Amendments by intentionally creating a second majority Black congressional district to remedy its discrimination in the 2022 congressional map that it created. And that map was found to be discriminatory by 7 different federal judges. So Louisiana's creation of a district to remedy that map was not atypical. It's actually what happens when you find when you have a finding of discrimination. So this re-argument raised critical questions about how Section 2 of the Voting Rights Act, which prohibits racial discrimination in voting policies and district maps, and is, among the Voting Rights Act's most critical provisions. The question was really about how it applies in Louisiana, and specifically, this could implicate whether courts and lawmakers can continue to use the law's tools to remedy maps that dilute the voting power of Black people and other voters of color nationwide.
So when you began your argument, which I was privileged to see in person, but also have listened to a couple times since then, I heard you reference Allen versus Milligan. Allen versus Milligan. Let's hear a clip of that argument now.
A mere 2 years ago, in Allen versus Milligan, a case nearly identical to Robinson, this court noted that under certain circumstances, it has authorized race-based districting to remedy state districting maps that violate Section 2.
What is Allen versus Milligan? Why is it important here in your case?
Allen versus Milligan is one of the most significant cases in this century, and that's no exaggeration. It's a LDF case that was argued by our now Director of Litigation, Duell Ross, and it's a case that is nearly on all, four corners the same as Louisiana versus Callais. It involves a congressional districting map in the state of Louisiana, where the state of Alabama did the same thing that Louisiana did, and that is it did not recognize the growing Black political power in that state, and it has a rank history of discrimination and contemporary discrimination that impacts the electoral process. So the Supreme Court's decision in Milligan reaffirmed that Section 2 of the Voting Rights Act protects against exactly the kind of racial dilution that we are seeing in Louisiana. It was issued just a mere 28 months ago, and it is very clear the principles are the same as they have been for 40 years. So respecting Milligan means respecting precedent and keeping faith with the promise of the Voting Rights Act.
I really love that part of the argument where you reminded the court that it would be illogical for them to not recognize Milligan having been entered by them merely 2 or 3 years ago, and then do a bait and switch 2 and 3 years later and decide something different with a case that's so identical on so many different in so many different ways. So that was a really good part of the argument for my part. So Justice Kavanaugh, who's a key member of the court, asked about an endpoint for race-based remedies.
What exactly do you think the endpoint should be, or how would we know for the intentional use of race to create districts?
What is the distinction between a remedy and a liability in a statute like Section 2, and why does that distinction matter?
It matters a lot because, remedies repair what's broken, and the law prevents the break from happening again. So you need to have the law in place. Justice Ketanji Brown Jackson, I thought, had a wonderful analogy and said that basically the statute is a tape measure.
It's a law that is just encouraging or requiring a check-in. It's like a tool. It's like a tape measure that we're looking as to whether or not certain circumstances exist, and those circumstances that Congress is worried about is unequal access to electoral opportunity. And Section 2 tells you we have to look for those circumstances, and then the court says, yep, they exist in this situation under Section 2, and so now a remedy is required.
The genius of Section 2 is that it has this built-in focus on current conditions that obviates the need for a sunset date. The statute is always working with current facts. And in other contexts, the court has declined to impose a sunset date on civil rights protections. And given the severity of our nation's experience with racial discrimination and exclusion, that's really important because Congress has banned discrimination based on race. So there's no question that bans on segregation or discrimination in contracting or housing or employment or public accommodations should be permanent. I can't imagine why it should be any different for this foundational right to vote. So Section 2 is about justice, not permanence. It's about ensuring the integrity of our electoral system.
And that I would offer is also another key and favorite part of the argument for me, which is sort of making clear to the court that racial discrimination, which is the mission of our organization to eradicate and permeate so many aspects of our society, that it's illogical to believe that there's a date certain by which it all sort of evaporates, particularly in the context of racial discrimination in voting, which, if you open up the newspaper, you can read about the way that race still matters and people's access to our political system. So some of the justices raised questions about the Section 2 framework needing to account for political objectives, and that plaintiffs need to do more to account for political polarization in proving Section 2 claims. How do you or did you respond to those concerns at argument?
Well, Section 2 is focused on ensuring equal opportunities for racial minority voters, not dictating specific outcomes or partisan results. It is not a political statute. It's about a right to vote. It's a constitutional statute, right? It enforces the 14th and 15th Amendments. So the record clearly demonstrates that there's racially polarized voting, and the legislature's choices diluted the political power of Black voters specifically. And we showed that in our briefing. Courts have applied Section 2 to districts drawn by both parties. LDF has sued both parties. So again, this statute is about protecting a constitutional right to be free from discrimination in voting.
So at their core, these cases, Robinson to Callais and Milligan, are struggles over power and who gets access to it. You and I have both had this rare, pivotal experience of arguing before our U.S. Supreme Court as Black women oralists, advocating for Black communities whose political power is on the line. And in that context, what does this moment mean to you, both personally and historically?
It's both powerful and humbling to stand in that space, knowing how few Black women have ever done so and how many people made it possible for us to be there. So when I look across that courtroom, I carry with me not just our clients and our colleagues, but generations of women and Black advocates who were once excluded from that very room. And having both of us, two Black women, arguing redistricting cases this decade concerning the representation of Black voters is absolutely extraordinary. And it also reminds me that representation matters, not just in Congress or on maps, but in the courtroom itself, especially in the highest court in our country.
Janai, hearing you reflect on that, on what it means to stand in that space, carrying the weight of so much history and responsibility, it brings home just how much is at stake. Because beyond what it means personally to you and me and others, the court's decision will shape what representation looks like for millions of Black voters across the country. As we look ahead, if the court were to rule against us in whole or in part, what would that mean for Black voters? And what do we do next?
So a ruling against us would roll back decades of progress for Black representation, especially in the South, where Section 2 has been one of the few tools ensuring that Black voters can elect candidates of their choice who truly represent their communities. It would reopen the door to the same discriminatory map drawing practices that the Voting Rights Act was enacted to prevent. This would strike at the heart of the 15th Amendment's promise. We cannot allow the 15th Amendment to become a parchment promise, something written on paper, but hollow in practice. And while we are hopeful, we're not naive that a negative ruling could be issued. And if that happens, we will need to assess how far-reaching the consequences are, but trust that LDF will consider every available path to continue ensuring that Black Louisianans specifically and Black voters generally are provided electoral opportunities. And at the same time, we are always going to continue our legislative advocacy at both the state and federal levels to enact state-level voting rights acts, to pass the John R. Lewis Voting Rights Advancement Act, which would further strengthen voter protections that were established under the Voting Rights Act. So we'll deepen our investment in local organizing and voter protection and civic engagement to safeguard representation on the ground. We're going to use every possible tool at our disposal, whether we win or lose, because that's what we do at LDF. This isn't just about Louisiana. It's about the future of Black representation across the country.
So if And dare I say, when the court rules in our favor, what
Yes.
immediate impact do we expect? And what will LDF focus on next?
If, or as you say, when we win, the first step is making sure that the remedy is fully and faithfully implemented in Louisiana and that it continues to provide electoral opportunities for Black voters in 2 congressional districts. We're going to stay close in partnership with our clients and communities on the ground to ensure that the remedy delivers meaningful representation. And we'll also take what we've learned and apply it elsewhere, replicating these same strategies and building networks and staying ready for the next fight. No matter how the court rules, LDF will be there, litigating, organizing, and defending democracy. If you believe in equal voice at the ballot box, now is the moment to stand with us and support us.
Thank you for giving us an inside look at LDF's fight for voting rights at the Supreme Court and for sharing what this moment means for you personally, but also our very important democracy.
Thank you.